That meant I was time barred, meaning I no longer would be able to argue my issues directly. I was instead relegated to arguing that the procedural ruling against me was inaccurate in order to have that reversed, to then go back to the lower federal court, to then have my issues argued directly. So I went to the United States Court of Appeals, and much like the State Court of Appeals, you had to obtain permission to appeal to them. I was granted permission, and my attorneys advanced 3 arguments as to why the procedural ruling should be reversed. Firstly, that this was not a delay caused either by my attorneys or by me, but in fact by misinformation by the court clerk. The second argument was that to allow a ruling like that to stand would be to cause a miscarriage of justice to continue, which kind of backdoors the innocence argument back into the case, at least as a contextual issue. And thirdly, that reversing the procedural ruling would open the door to more sophisticated DNA testing of the type which would go on to clear me 7 years later. Now, one of those two judges who was deciding this issue here would go on to become United States Supreme Court Justice Sonia Sotomayor. Once again, the district attorney opposed, and once again, the court sided with the district attorney. My lawyer moved to re-argue the case in front of them, in fact, requesting that all the judges on the circuit hear and rule on the case. That's how strongly she felt about it. But the re-argument motion was denied. That meant we had one court left to go to, the United States Supreme Court. Nationwide, that court agrees to hear only between 2 to 5% of all matters that come in front of it. And included within that small figure was a certain amount of civil matters. So we knew going in that despite compelling reasons of justice as to why they should do so, the odds of them agreeing to do so were slim. Having no other court left to go to, I had no choice but to forge ahead. I was not able to overcome the odds. As expected, the United States Supreme Court declined to give me permission to appeal to them. That marked the end of my appeals and the end of legal representation. That was in 2001. The path, therefore, to overturn my conviction and therefore to regain my freedom would be that I would first have to somehow obtain an attorney who would take my case for free, for neither I nor my family had the funds with which to hire one. Then hope that we could find an investigator willing to work on a similar basis. And then hope that in collaboration they could somehow find some additional unknown evidence of innocence, without which the court was no longer willing to hear from me. So my legal work, if you really want to consider it that, consisted of writing SOS type letters to anyone and everyone I could possibly think of who could help me, either directly or indirectly. I wrote large law firms because I had read that such firms often have a pro bono section in it, which they would take cases for free. I very rarely heard back from them. When I would hear back from them, they would tell me that they had no time to take my case for free, although they always made sure that they never closed out their letter without telling me how much money they wanted, should I somehow be able to scrape it together. Reading between the lines, I guess what they were saying was that if I had the money, then they would have the time. Then they would end their letter by saying, good luck, as if I'd be okay despite their non-intervention. I wrote reporters, especially those who had written on other wrongful conviction cases or issues, reasoning that their general familiarity with the subject matter would put them in a better position to understand what I was saying, and maybe they would dig around and write an article or two, and therefore my case would get the